Alright, Group 6, settle down. Today we are dissecting the conflict of international laws in Malaysia. You have done the research, you have done the poster. Now convince me. Let's start with the basics. If I'm a judge in a Malaysian court and a lawyer comes in waiving a UN treaty that Malaysia signed yesterday, do I have to follow it? Aina?
Short answer? No, madam, you don't. Malaysia follow the Dualist Doctrine.
Dualist? That's a fancy word. Break it down for the class.
So basically, it means we view international law and domestic law as two completely separate systems. They don't touch unless we make them touch. Just because the executive, the government sign a treaty, it doesn't automatically becomes law in our country.
Exactly, it's about parliamentary supremacy. For a treaty to have any legal bite in our courts, it has to go through a legislative transformation. Parliament has to pass a specific act to incorporate it.
Okay, it is a good example. What does it look like when we do it right?
A perfect example is the Geneva Convention Act 1962. Parliament passed that specific act, so now the Geneva Convention are enforceable law here. But without a specific act, the treaty is just a promise on paper.
Good example. So Parliament is the gatekeeper. Can you give me a solid authority for that? I don't just want theory, I want a case law.
We have a classic case, which is Government of Malaysia and Loh Wai Kong, 1979.
Alright, tell me the story. What actually happened to Loh Wai Kong?
So, Loh Wai Kong was a Malaysian citizen who want to travel abroad. But the government refused to issue him a passport. He argued that under international human rights principle, he had a fundamental right to travel.
And what did the court say?
The federal court disagreed. They said passport is a privilege, not a right. More importantly, they ruled that even if international treaty says you have a right to travel, those treaties have no force in Malaysia unless they are incorporated by legislation.
Harsh, but it set the standard. Now let's talk about when things get messy. What happens when domestic law says A and international law says B? Who wins the fight?
Obviously, domestic law wins every time.
Every time? Give me an example of a strict dualism approach when the court really puts its foot down.
Oh, that would be the MBf Capital Bhd and Dato Param Cumaraswamy, 1997.
The special rapporteur case. Can you give me the background facts?
Sure, madam. So, Dato Param was a special rapporteur for the UN. He gave interview to the magazine about the corporate conduct in Malaysia, and MBf Capital disliked it. They sued him for defamation for RM60 million.
Dato Param claimed he had immunity from legal process because he was working for the UN. The UN Charter says he should be immune.
But the Malaysian High Court didn't care.
No, the High Court looked at the book and said, we don't have a domestic law that gives you this immunity yet. They rejected the automatic application of the UN immunity.
It actually got quite embarrassing. The International Court of Justice had to intervene in 1999 to tell Malaysia how we were wrong, but it really highlighted how resistant our courts were to unincorporated international law.
A very strict interpretation indeed, but law evolves. Is it always rigid? Did you find any cases where the judges were a bit more flexible?
Yes, madam. We found a shift towards a harmonious approach. The best example is Noorfadilla binti Ahmad Saikin and Chayed bin Basirun, 2012.
The Noorfadilla case. That is a very emotional case. Can you tell the class what happened to her?
Noorfadilla was a substitute teacher, or known as a guru sandaran. She applied for the job, got the offer, and ready to start. But then, the education department found out that she was pregnant.
All because she was pregnant. They revoked her teaching offer. They literally cancelled her job.
She sued the government for gender discrimination. Now, Malaysia had signed CEDAW, which is Convention of Elimination of All Form of Discrimination Against Women. But we hadn't made it an act for Parliament yet.
So under strict dualism, the court should ignore CEDAW, right?
Technically, yes, but the judge, Justice Saleha, did something different. She used CEDAW to interpret Article 8 of the Federal Constitution regarding equality.
It's like she used international law as a flashlight to see the domestic law better. She didn't apply CEDAW directly, but she used it to say discriminating against a pregnant woman violates Article 8.
That's a great analogy, Hafiza. So the rule is, if domestic law is ambiguous, we can pick at international law for help. But what if domestic law is crystal clear?
Then you cannot pick. If domestic law is clear, the court must enforce it, even if it violates the international law.
Okay, let's pivot to the other sources of law. We talked about treaties. What about customary international law? Does that work differently?
A little bit, madam. So, customary international law can be used as guidance, but again, it's limited. It cannot override clear written laws.
Did you find any case for that?
Yes, public prosecutor against Noorfadilla Sukhbavit.
Okay, what was the story of the fisherman?
In this case, a group of Thai fishermen were caught in the Malaysian waters. They were charged with illegal fishing. Their defense was that they were just passing through, exercising the right of innocent passage, which is a custom in international law.
Okay, and the court's decision?
The court confirmed that while innocent passage is a real international custom, Malaysia had a specific Fisheries Act. The domestic legislation was clear about catching fish in our water.
So, looking at your conclusion and recommendation, Malaysia is basically stay to or nothing. What is your group's take on this? Is the system working?
To be honest, it's a double-edged sword. On one hand, it preserves legal certainty. We know exactly what the law is. It's what the parliament passed.
But on the other hand, as we put it, our recommendation, it leaves gaps, especially in areas like human rights or refugee protection. We signed these treaties, but without statutory incorporation, the obligation remains unenforced domestically.
So, what's the solution?
The solution is legislative action. We can't just rely on judges to be harmonious. If Malaysia is serious about its international commitments, Parliament needs to proactively pass laws to match those treaties.
Legislative action to ensure effective compliance. I like that. It puts the burden back on the lawmakers, not the judges. Alright, Group 6. You have covered the Dualist Doctrine, the facts and the rulings of Loh Wai Kong, MBf, Noorfadilla, and the Thai fisherman case. That's a solid presentation. Any final thoughts before we wrap up?
Yes, just that Malaysia is slowly opening up. But for now, domestic law is still the same supreme law of the land.
Good. Class dismissed. Good job, Group 6.